SJC-13535, Zurich American Insurance Company et al. Versus Medical Properties Trust, Inc. et al.
Okay, Attorney Page.
Good morning, Your Honors. May it please the Court. I'm Creighton Page on behalf of one of the appellants, Medical Properties Trust, which I'll refer to today as MPT. Your Honors, in the question that's been certified to this Court by the First Circuit, there is one critically important word that establishes the analytical framework for how to answer that question, and that word is unambiguously. The certified question asks whether rainwater that lands and collects on a building roof 1 or more stories above the ground unambiguously constitutes surface water under this Court's prior precedent and for purposes of the insurance policy that's been issued to MPT. Now, each of the parties here thinks that its interpretation of surface waters is correct. We obviously think we have the better argument. The certified question should be answered in the negative. No doubt Zurich thinks it has the better argument too. But in order for Zurich's interpretation of surface waters to be adopted, it's not enough for it just to have a good argument, or even the better argument. That's not enough to establish that Zurich's interpretation of surface waters is unambiguously the correct one.
Well, we always have two sides, and everybody's saying mine is clear as day. That doesn't make it unambiguous, just because there's two interpretations that the parties are vying for.
Of course not, Your Honor, and this Court has held that on a number of occasions, that just because there is a dispute about the meaning of the words as between the parties, that by itself is not enough to make it ambiguous.
Okay, and how does your case differ from all of those others?
Because where there's just a dispute and one side's competing interpretation is determined to be not a reasonable one, right? So the way that this Court has described what it means for policy wording to be unambiguous is that it is not susceptible of more than one reasonable interpretation. Reasonably intelligent persons would not disagree as to which of the competing interpretations is the proper one. There has to be no doubt as to the meaning of the words, because doubts as to the meaning of the words are resolved in favor of the policyholder.
So you think your interpretation of surface water is not the only reasonable one?
Our case, Your Honor, has always been that taking the words that this Court used to define surface waters in its prior precedent and giving them a straightforward application to the facts of what happened when the rainwater landed and collected on the roof and infiltrated the building from above, that our case has always been that there is a straightforward and unambiguous way of applying those in order to rule in our favor.
What is the precedent that you're relying on?
In defining surface waters?
Exactly. You referenced in your answer to me that there's a straightforward precedent from the SJC. What is that?
Sure. There are 3 cases from this Court that have addressed the meaning of surface waters, 2 of them more recently in the insurance context in discussing what that term means in a property policy. Boazova, Sarabian, and in each of those 2 cases, they took the definition of surface waters from De Sanctis. And the way the Court defines surface waters in those cases is the same in each instance. They are waters from rain, melting snow, springs, a few other natural sources that lie or flow on the surface of the earth and naturally spread over the ground, but do not form part of a natural watercourse or lake. That's the way the Court defined it. And so the question here is, do those words that this Court has used to define what constitutes surface waters, does that describe rainwater that lands on a building roof, dozens, perhaps hundreds of feet above the ground, and becomes trapped there, and which never lies or flows on the surface of the earth, and never naturally spreads anywhere other than the roof on which it landed? And our position is that the answer to that is we think unambiguously no. But again, the reason why I started with this as being the proper analytical framework.
Although the First Circuit obviously didn't, in its fidelity case, thought the opposite, right?
Wouldn't necessarily agree with that, Your Honor. In the Fidelity v. Nova case, and I'm sure you will have seen this from the briefing below and what transpired in our interlocutory appeal to the First Circuit, but that case was actually decided on completely different policy wording. It was decided on the basis that there was coverage under that policy for a provision that expressly granted coverage for drain overflow, and that a rain limitation in that policy did not apply. That's why the policyholder won in that case and why the policyholder was entitled to its complete judgment without any deductible. The question of whether or not the rain on the roof in that case was surface water is something that the district court had characterized it as such sua sponte. When it came up on appeal, that was not contested by the insurer there. For the First Circuit said that in its opinion, and the actual question that was presented there on the First Circuit in that case was where the water on the roof has been determined to be surface water, right? Because the district court said so. Right. Do the unambiguous terms of this policy provide coverage for that, or do they exclude it? And the district court's error is that it had overlooked an endorsement that would provide coverage for that. But that was very much a secondary part of that case, and not one that impacted the judgment in any way. The parties did not go back and forth citing the same arguments we're presenting here, for example.
But we also have Judge Saris in this case who carefully sort of pieces this together and says that it does deal with the roof, right? In her first, at least her original sort of conceptualization of this is our precedents do extend to the roof.
I think what Judge Saris was really saying in her order, Judge Saris thought that she was bound by the Nova decision. She thought that the First Circuit had already addressed the question that we have here and reached a...
So it wasn't quite as simple to distinguish as you just said then, right?
Well, so she thought, and this is what she said during the oral argument on the summary judgment hearings in that case, so I can't go to the First Circuit and say that they're wrong, right? And then she said, I acknowledge the force of what you have to say, this is in the transcript, about what the SJC has said in defining surface waters. So she said, what she ultimately did is ruled against us in favor of Zurich, but recognizing how close of a call it was, that it was not clear, sent it to the First Circuit for interlocutory appeal, and now the First Circuit has clearly said that they don't think that Nova is dispositive of the question. Otherwise, they would have gone back to Judge Saris and said so, instead of certifying the question here. So I don't think we should treat Nova as being something that is dispositive of the case, certainly not that. I don't think it's even instructive because the question there was so different.
Can I ask a more basic question? Because the amicus briefs describe sort of these catastrophic consequences of both positions. So rainwater in our roofs. Okay, so we have one amicus brief saying that normally every insurer thinks their house is covered against a leaky roof. Is that your sense that's correct, that leaky roofs, what's the provision in the insurance that covers leaky roofs if it's not? So I just want to make sure I understand the background assumptions well.
Sure, Your Honor. And I guess the question would be, is there a provision in the policy that takes away coverage for rainwater intrusion?
So what's the provision that covers it? So the normal property insurance is covering my leaky roof when it's pouring out there, and these new rainstorms we're getting where, like we're Noah's Ark, it's coming down nonstop. So we're covered, and you have to exclude it through this flood insurance provision? Or I'm just trying to make sure I understand the background assumption so we don't accidentally create some problems here.
Sure. The standard homeowners policy, as well as the standard commercial property policy, includes a few different provisions that are relevant to this question that you're asking now. One of which is the so-called water exclusion, which includes the surface water piece of that exclusion, which is what was at issue in Boazova and Sarabian. The next one that's critically important is what we refer to as the rain limitation. And the rain limitation in the standard policy, it takes away coverage for damage to the interior of the building that is caused by rain or snow, sometimes some other causes, sleet, unless the exterior of the property was first damaged by a covered cause of loss, or unless I think it was, it's the circumstance that deals with ice dams, if it's a function of the melting snow or ice that comes in. Now, what the rain limitation doesn't say, it doesn't say we exclude coverage for damage caused by rain, period. Rain is not an excluded cause of loss to the exterior of the property. And there are cases not in Massachusetts, but in other jurisdictions that it's so held. So if the rain damages the roof of your building, for example, as there is evidence here that it did, and then the rain comes in and damages the interior of your building, then yes, there is not an exclusion in the standard policy that takes that away, unless you were to consider the rain on your roof to be surface water, in which case it would come within the surface water exclusion. That's why the decision on this certified question reaches so far beyond just the parties to this case. Now, all of a sudden, if accumulation of water on a roof
I assume he's going to stand up and say, no, that's not, you need to have this kind of giant puddle effect for it. Normal rain that leaks through the roof is not going to be what we're dealing with. It's when it's like this, where you get basically a swimming pool on top of your house.
If my brother stands up and says that, it will be very different from the position that Zurich has taken in its briefs, which is quite clearly that they believe that as soon as rainwater hits anything, whether it's the ground or any other surface for that matter, that it becomes surface water. That's the position that they've taken. Now, we disagree with that. And if rainwater accumulation on a roof, just to complete your question about what are the consequences here for the standard policy, if that's now surface water, then so too is snow accumulation on the roof, ice dams. I don't know, but I've dealt with ice dams before and had to go to my insurer to get coverage for that. I don't think there's any dispute that damage caused by ice dams is typically
I
covered.
thought the policy wasn't that surface water was excluded, but that there was a limit, a cap.
I'm sorry, in which case are you referring to?
Yours.
Maybe you can repeat the question. I think I missed at the beginning.
So my understanding, and of course you know more about this than me, but was that there was a cap on the coverage for surface water, not that it was excluded.
You're right.
Okay.
You're on it.
So this parade of horribles about ice dams and whatnot would have to fall within the cap if we concluded that such things were surface water.
Justice Kafker's question was about the consequences under the standard homeowners policy, the standard commercial property policy, which this is not one of those.
Right.
Right, but I have the same question Justice Wentland does, because it's a sublimit, right? That's what this is called?
This is about how to construe the sublimit in the policy for damage caused by flood. And so what that sublimit does, otherwise, there's no question that damage caused by water or anything else that is not an excluded cause of loss is covered under this policy, which has overall limits of $750 million. The application of the flood sublimit takes away coverage for all of the damage that exceeds $100 million, at least insofar as the flood sublimit applies to it. And so that's the question that we're dealing with here. It is definitely a limiting and exclusionary provision. Courts have always dealt with sublimits that way. Is that?
Right, but it's not that it's excluded from the policy, it just has to fall within the $100 million limit.
In our policy, we're not talking about taking away all coverage for all of the damage to the hospital. We're talking about taking away tens of millions of dollars of coverage for all of the damage in excess of $100 million. To Justice Kafker's question, in the standard policy, we would be talking about taking away all coverage for all damage caused by water accumulation on the roof.
Can I just we have not much time left, with one question. In Fidelity, am I correct that the implication of reading surface waters to include the rain meant that coverage existed, which is the opposite of the situation here? Is that correct? Okay.
It's absolutely correct. It would have been another way of finding coverage.
Understood. So what I'm interested in is the question of how we deal with ambiguities. And obviously, ambiguities are generally construed in favor of the insured, and that is a strong part of your argument here. Can you tell me what you think the practical differences are if this court were to rule for you on the grounds of ambiguity versus the grounds of it's unambiguously in your favor, because I'm thinking about other cases, and I'm interested to know, are there other policies where surface water is used in a way that would, if ambiguous, flip the other direction, and would that cause problems to have surface water mean one thing in half insurance contracts and one thing in another?
Well, it's an excellent question, Your Honor, and I think the best answer to that, what are the consequences of ruling in our favor, finding that these words are susceptible of more than one possible reasonable meaning in the policy, is that it tells the insurers who are writing these policies using the term surface waters without having defined them to mean whatever it is that they want to argue they mean now, that they need to be a little bit more careful in the drafting of their policy language. It is the insurer's burden when writing an exclusionary provision in a policy to state that wording in clear and unmistakable language. That's what this court has said. And so if the word surface waters is being used in the policy without having defined it to mean something other than what this court has defined it to mean, then I would submit that the insurer has not met its drafting burden in that case, and that it's not this court's job to relieve it of that drafting burden after the fact by construing surface waters so broadly as to encompass something that it could have written in the policy in the first place, but chose not to.
But if we say it's unambiguous and it means what you say, what are the consequences more broadly beyond your case? I understand the canon of construction that we construe things that are ambiguous against the insurer, but what if we decided you're right, unambiguously? You win, but what are the consequences for the industry?
Well, it may be the case that that insurers would read that and decide that they want to be more specific in their
What would
policy
happen to
drafting
the
anyways.
Novas of the world, I guess, is what I'm wondering.
I'm sorry, say it again.
What would happen to the Novas of the world, the Fidelities of the world, in that case, post our decision that it's unambiguous that surface water must run on the earth and, I don't know, dilute unlike a natural waterway?
In that case, it would have made no difference at all because NOVA already had coverage under the drain overflow provision. It did not need the flood endorsement and any surface water coverage in order to find coverage. In fact, if it had been relying on the surface water coverage and the flood endorsement of that policy, its recovery would have been $25,000 less.
So there wouldn't be cases where, I thought Justice Stewart's question was, are there cases where the only way you're going to get coverage is fitting in within this definition of surface water, and therefore, if we interpret this to be ambiguous, it's gonna, it's the opposite effect. I mean, I guess that's.
Well, so the circumstance in which that would be the case,
Meaning
where
it's a coverage rather than, maybe it's the same effect, that it's still going to benefit the person seeking to claim under it, I guess. Is that right? Under either context, or?
if you're a policyholder and your only source of coverage is under a policy provision that provides coverage for damage caused by surface water rather than taking it away, and you hold that the wording of surface water, if it's not more specifically defined, is ambiguous, policyholder is going to win in that situation. It's entitled to the benefit
So
of the,
either way, the policy, ambiguity is going to help the policyholder both in terms of coverage and avoiding the exclusion.
I think that's right, Your Honor, yes. And the only, I see that I'm 3 minutes over. I don't know if you want me to address this. Okay. This is because the question was posed about what is the circumstance where you might have a policyholder who needs surface water to include water on the roof in order to get coverage. And the only thing I can think of in that situation would be where a policyholder's only source of coverage is a flood policy, where flood is defined as, and it might be defined in any number of ways. If it's a standard flood insurance policy, it would be the inundation of 2 or more acres of land or 2 or more properties that is caused by one of the enumerated things, where surface waters is one of them. In our policy, you see that the flood definition is the inundation of a normally dry land area or structure caused by surface water. If that was your only source of coverage for the water damage at issue, then you would need it to be so. But that would be highly unusual, Your Honors, for you to have flood coverage but not otherwise have water coverage subject to the standard exclusions.
Can you give us a sense of whether your view of what we say surface water is that in the majority or the minority view of other jurisdictions?
You've seen some back and forth on this in the briefs, Your Honor, and my view, if you look at the cases that have been cited, is that more of them come out in favor of MPT's interpretation of surface waters than do for Zurich's. And what I would hope that you have appreciated in looking at the cases that Zurich and its amici have cited, about half of them involve the flow of water over a ground surface into the ground floor or the basement of the property at issue. That's what happened in Cameron, it's what happened in Crocker, it's what happened in Smith, it's what happened in Capital Mortgage. And in 3 of those 4 that I just mentioned, the court specifically, well, in 2 of them, the court specifically distinguished, and the other, the insurer itself specifically distinguished that situation of water flowing over the ground into the property from water that comes in through the roof from above. So in Cameron, the insurer, there was water damage that came in from the roof through above. And the insurer conceded that that was not subject to the surface water exclusion. In Crocker and in Smith, the court looked at cases that have held water intrusion through the roof is not surface water, like the Cochran case in Louisiana. I think that's the one that I think maybe the Georgia and Florida decisions as well were looked at in those cases. And it said, what we have here is something completely distinguishable from that. Water flowing over the ground, over a patio, over the driveway, into the building on its ground floor is not at all like rainwater that comes in from above through the roof.
Well, it's the same rainstorm. Yeah, it's the exact same rainstorm. That's the problem, isn't it? And the water that's flowing off the roof is going to be at the bottom of the building, coming in to the building the other way. So it's hard to completely separate the two, right?
And I think what Your Honor is touching on now is some of what was driving the Martinez court in the Colorado case that Zurich has relied on. And it stole this phrase that a building roof is just an extension of the surface of the earth at that point from the Bringhurst decision in Delaware, which was in entirely different circumstances. And in Bringhurst, the roof had to be considered an extension of the surface of the earth in that case because there was no land on the property from which
The whole
surface
thing
water.
was covered by
Exactly,
the roof.
right. So I think that these insurance coverage cases stealing from Bringhurst in support of this, to me, seems entirely misguided. But in Martinez, the court could think of it that way because it wasn't a flat enclosed roof like what we have here. It was a roof like you think of on most homes that slopes down. And so the rainwater hits the roof and it flows off onto the ground, as it did in that case. It landed on the roof and flowed down to the ground in the window wells. And so, yeah, you might tend to think of it a little bit more differently in a case like that. But again, that's not our case.
Okay, thank you very much.
Thank you, Your Honors.
Okay, Attorney Hofer?
Madam Chief Justice, and may it please the court, Patrick Hofer for Appalachia Zurich and American Guarantee. Just blocks from this courthouse, there are entire neighborhoods that consist of buildings that are built right next to each other, where if you look from above, the entire block is nothing but roof. This includes residential row houses and commercial buildings with low slope roofs that have a parapet wall.
Can I ask you, are we applying the DeSantis standard in this case?
I'm sorry, Your
Are
Honor.
we applying the DeSantis standard in this case?
We start with where the language in DeSantis comes from, and that goes back further than DeSantis.
Okay, but is the term surface water we are applying in this case is water from rain, et cetera, correct?
Exactly.
Okay. I get the surface of the earth, which is, you're talking about your row houses, and the roof is an extension of the surface of the earth, it's metaphysical. But how do you deal with the naturally spread over the ground part of that, dealing with pooled water on a roof that never hits the ground?
So DeSantis, of course, didn't involve a roof. It involved marshy land in Saugus. And didn't have to consider whether water on a roof constituted surface waters or not. It used language which the law had defined for over a century which distinguish natural sources of water.
So you want to read out of De Sanctis in our subsequent cases, the naturally spread over the ground part of the standard?
No, it doesn't. You don't need to read it out. You just need to read it in context. And so the context of the law's definition of surface waters was to distinguish sources of water, and there were three kinds. There's water in a channel, a natural channel, like a stream or river, water in a body, like a lake or a pond, and then everything else that is not contained and not channeled. And that was called surface waters. And the history of this court's decisions over time consistently agreed that surface waters includes water on a roof. There are many cases, we've cited them, where the courts had roofs at issue. And the court said, yes, this water's on the roof, that's surface water. Next case, yes, water on the roof, that's surface water. In Cochran in 1919, the court said, this is the familiar rule. So yes, where we're dealing with waters on a roof, the court's consistent precedent has been that is surface waters for purposes of our legal classification.
All rainwater is surface water on the roof?
When it accumulates,
Well,
and
but it always accumulates a little bit, right? I mean, if it's raining hard, there's always some accumulation. I'm just trying to make sure sorry, Justice Gaziano, are you?
No, I can get my question answered, but
Yeah, go ahead.
well, I'm sorry, I meant to answer
I just
your
don't
question.
get, the naturally spread over the ground troubles me in the application in this case, and I don't think
Go
it's
ahead and do
satisfying.
I
Come
understand.
back to me.
May I answer Mr. Justice Gassiano's question? The answer to your question is that part of the statement in De Sanctis about what surface waters is was necessary to the holding in that case because it involved water on the ground. But if we look back further into the history of the term and this court's precedent, it is clear it doesn't have to be on the ground.
What cases?
We start with Field versus Gowdy and Cochran in 1919, the case that I just mentioned, said, cited Field v. Gowdy and multiple other cases which said, this is the familiar rule.
But in Field v. Gowdy, the water was on the ground, right? The water that caused the damage that froze and someone got injured or...
Yeah, it was started on the roof, and then the court very clearly said that the surface water came from the roof, was channeled through downspouts or gutters, and then
Into the ground?
onto the ground.
Yes.
Naturally
So
spreading
what
over the
about
ground.
Cochrane? What about Cochrane? Was that never on the ground? The earth?
It started with water on the roof.
Well, I mean, sure. The water, as we all know, comes from the cloud, so...
No, but the legal construct that the
Yeah.
court was using about liability and your obligations and do you...
So I guess my question is, in Cochrane, was the water on the ground at any point?
Eventually, yes.
Okay, thank you.
Yeah, and that's what I'm asking, because in this case, we have water that pooled on the deck, the second-story deck and the roof.
Yes.
And never went down went into the building. I guess eventually it gets to the ground, but causing the damage before that.
Correct. Well, but the factual issue in all the cases that we cite, yes, the water did reach the ground, but that wasn't why the landowner had liability. It was because if the water hadn't been redirected artificially through a downspout or a channel of some sort, the landowner wouldn't have liability because the water on the roof is surface waters, and that falls where it may.
But doesn't that derive with what the landowner did or did not do with the artificial structures on their property which directed water? It doesn't
Yes.
really have to do with the classification and nature of the water. This is a contract, and we have to interpret the contract, and it specifies different kinds of, as you helpfully suggested, like there's different categories of water. Can you respond to the argument about, our familiar canon of construction that we should interpret the word surface water in keeping with the other items in the list in the flood limitation, which are like tsunami, waves, and so forth?
Right. So the taxonomy or the classification used in that definition mirrors the same classification used by the law. There are sources of natural water, natural sources of water. And that's what the law used. And that's why surface waters is really a law term. It's not merely a contract term. Both parties agree that the law's definition of surface water is what controls here. And so, yes, the breakdown identifies various sources, but not all of them have to be on the ground. And surface waters, I think probably just surface waters, all the others, of course, natural bodies are on the ground. It doesn't have to be on the ground, and that's what the law has said for over 150
So
years.
surface water is precipitation then, under your definition?
It is, when it accumulates on a surface, yes. And
So
in
all
Boazova, the
So
court
all
said,
precipitation,
that's
surface
essentially what it
water.
is. If it's unchanneled, undirected, uncontained, and accumulation, yes.
So does that pose the problem identified by the amicus, that every time it rains and the roof leaks now, that fits within the surface water rather than it's not covered?
No, Your Honor, because the amicus forgets that for flood coverage, which is what we have here, you have to have more than a leak. You have to have inundation. You have to have something.
Right, but I'm trying to understand the background assumption. When it rains hard and the roof leaks, how is that covered or not now in your world, where surface water includes any precipitation on the roof?
Where we have flood coverage as defined here, and it has a rapid and unusual accumulation.
So it requires an unusual accumulation? Because, again, I'm trying, we don't want to do damage to the entire insurance industry out here. So we want to try to understand what you're saying. Are the amicus wrong that leaking roofs are now, in your view, surface water, so we don't recover for those? I'm just help us out here, because...
Yes. So I'm drawing a distinction between coverage for flood and exclusion for flood. In a very typical policy, flood is excluded.
Right, but a rain is not always a flood, right?
And rain, there may be coverage for rain damage, not by flood.
So, but maybe, they're saying that the way you're interpreting surface waters is going to eliminate that.
No, Your Honor.
Why not?
Because the coverage for rain damage, not flood, so there doesn't have to be accumulation, rain damage to the interior of the property is covered unless that is excluded, unless that rain entered through damage to the roof.
So it's excluded. So you're saying...
Typically excluded.
So you're saying the amicus are correct that... Oh, no, you're saying rain is typically excluded.
Typically, so if there's wind-driven, if the rain damages the roof, in my brother Mr. Page's example, if the rain damages the roof and the rain enters through that damage, yes, and then that would provide coverage for the water damage.
What would provide coverage?
It's called the rain limitation in the policy. So rain damage is excluded unless there's damage to the roof that allows the rain to enter.
But under your theory, they would no longer get coverage, correct? Because the water that was on the roof is surface water, and it would therefore be subject to the flood exclusion.
No, Your Honor. No, because so this was actually the issue in Fidelity versus Nova. This is the two competing provisions.
If there's debris in the gutter and it doesn't drain, then there's some accumulation of the rainwater, right? Then it becomes surface water and it's no longer covered.
So if there's damage in the roof, it doesn't accumulate. It goes through the damage.
No, I get what you're saying. If it's wind driven and the rain penetrates, which happens in my town constantly, so rain penetrates, that's covered under your vision. But what I'm saying is, if it's accumulation and then it penetrates, it becomes surface water.
Exactly. And if there's coverage, as there was in Fidelity for surface water, then that coverage applies. If it's excluded, the surface water is excluded.
So it would all turn on a sort of post hoc determination of how deep the water got on the roof?
The way the water entered the building, I think, is the way, and it is, yes, these
Either
things are...
directly or via accumulation or stand-in water, essentially.
Yes, well, so here the facts are the water accumulated to a high degree on the roof of the building, and that's why MPT's argument is that the significant flood really isn't a flood. But of course, it is a flood. This is an incredible inundation. And they rely on the surface water argument to say, well, this wasn't surface water, but we go back to how the court has defined surface waters for over 100 years. It's exactly how the court has
Well,
treated.
sorry, the 2012 cases, though, define surface water in a very specific way that is not what you're saying, because it specifically refers to flowing over the ground. And so I'm interested in your observation that the word youth are saying that you think the word surface waters is essentially a legal term, like a term of art. And but a lot of your arguments are relying on dictionary definitions of the word surface, which are, intuitive definitions that would definitely include the roof, like it's a surface of the earth. So can you reconcile those 2 points?
So Bozov and Sarabian, the 2012 cases that you just mentioned, actually sort of drew back a little bit from De Sanctis, because the court didn't hold in those cases that the water has to touch natural soil. It can be on an artificial surface.
Yeah, but that was just the raised patio.
The patio and the parking lot.
Right, right.
Yes.
So the patio was on the same level as the ledge
Correct.
in the house, right?
But the challenge in those cases was, in De Sanctis, the suggestion was it has to cover the ground, has to be on the surface of the earth, and the court said no, and these in context of exclusions. The court said no, it can be an artificial surface.
That's on the ground.
Right. So so here, of course, the roof, we have an artificial surface. It's higher than the ground.
That's the issue, right? Is how high up?
How
high up is that patio, right?
One of the roofs is a courtyard where people walk and have lunch. So, many ways it is the ground. And of course, other surfaces are higher. And that gets into, well, are we dealing with a height test? Is a patio on the ground, surface of the earth, but a courtyard a little bit higher?
But if you're an ordinary person and you walked into, I forget, was it the second case, the patio case?
Bozova.
If you walked up to that patio and you said, is that on the ground? A normal person would say, yeah, it is.
Yes.
And then if you went up to Norwood Hospital and said, is that thing on the ground? Everybody says no.
And the courtyard. So the courtyard, where they say, if they're having lunch on the courtyard, is that the ground? I think many people would say yes.
Well, if you're on the elevator and you hit the ground floor, you're not going on floor 2, right?
So
I can see that, Your Honor.
Okay.
you're my insurance broker. I retire from this court. I want to buy that building. And I want insurance. I want to buy insurance for that. And I want to cover these different problems. It now rains a hell of a lot in Massachusetts. What do I buy? How do I protect myself from this happening again? What kind of insurance do I buy?
I think you buy the
what do I-
policy my client sold. And my client, we provided flood coverage.
So again, I've got 3 different kinds of damages. I got a hard rain, and it may come into, you're my broker. I want to protect myself from a hard rain going into the building. Am I protected by the basic policy?
No.
I'm not. So what do I buy?
You in a commercial property insurance policy like that sold here,
Yeah.
you buy flood coverage.
So I have to buy flood coverage to deal with hard rains on my roof.
Because,
But I can't get flood coverage, can I?
yes, you can. Absolutely, you can. The flood, I've been litigating.
But again, I bought this building now. I just bought it from Seward Hospital. I now have to buy flood insurance to cover rain pouring through my roof.
Yes.
Okay. And then okay, that's your answer. Okay.
Yes, Your Honor. I see my time has elapsed. Thank you very much.